Trustee, Aswini Weereratne Head of Chambers at Doughty Street, and we're really lucky to have her with us today. Over the course of Aswini's 30-year career, she's dedicated her practice to protecting the rights of vulnerable individuals, including survivors of child sexual abuse and exploitation, across courts and tribunals in this country at all levels. Thank you, all three of you, for joining us today. So as I mentioned, iProbono is a global group of organizations. Today's event focuses on iProbono India's child rights program. India is a country where children are protected by a robust and comprehensive legislative system. It's informed by international norms which prioritize the best interests of children at every point in the implementation of this work. The Protection of Children from Sexual Offences Act, you're going to hear it referred to as POCSO, is an important piece of legislation. Akanksha is going to provide some more context to it, but it's a really important example of modern legislation designed to protect children from sexual offences. It's good law, and it prioritizes the well-being of children throughout the judicial process. Despite the existence of this kind of law, of course, gaps remain between the legislation and its implementation. I think this is going to be really familiar to many of you working in different jurisdictions. Challenges will be familiar to you, and they're compounded by variations in how the law is at one level applied across different states in India, and each under the jurisdiction of its own high court as well. Priya and Akanksha are going to go into more detail on this. I feel that as lawyers and activists, it's our responsibility in many ways to bridge these gaps, to ensure that child protection is effectively implemented to all children in India. That's the ideal. This requires grounding policy in the lived experience of stakeholders. You're going to hear case studies about these lived experiences, and also continuously working to track and drive meaningful changes. And that includes tracking how our decisions in judgments, etc., impact other children within the system. Priya and Akanksha are going to share examples of some of the barriers that they've encountered during their own practice when implementing the relevant legislation, and also interesting and innovative strategies that they've used to combat threats to child welfare. Crucially, I think that today's discussion is going to highlight the importance of collective action, that's all of us working together across legal and civil society to reconcile some of the gaps that we've recognized in the system. So following the case studies, Aswini is going to lead a moderated discussion with our speakers, and you'll also have an opportunity to ask your own questions, which I'm really interested and excited about. Before we begin, a few housekeeping notes, which Lottie has shared with me and wants me to read out. There are information packs on your tables, which have been provided to share some summaries and more information about the legislation in India. There's also a map of India for some of you there who don't perhaps know where our jurisdictions are exactly. Akanksha and Priya are going to speak for about 10 minutes each, followed by a 20-minute moderated discussion with Aswini, and about 10 minutes for Q&A, I think. If you do have a question, just raise your hand and I'll bring the mic to you. And those of you who've joined us online, do share your questions in the chat box, and we'll definitely try and address those as well. I think our presentations will go on till about 6 p.m. and following that, we'll have an opportunity for in-person networking and conversations too. This session is being recorded. I hope that's okay with all of you, and do request a copy of the recording if you'd like after the event. I do want to start this discussion with a really short film about Amal, one of the first children that we represented at iProbono at the Delhi High Court. We now run over 250 cases across trial courts in India, and we impact thousands of lives. So thank you again for being here. Doughty, I think you'll have to help me. It's a little bit higher.
both as channels के कोशिश भी बन सकते हैं.
Assistance to civil society organizations as well as Islamic institutions. To have set up a child office for we were informed from this case where grave injustice. So our role was to file a plea against the author of the note. Within a very short span of 2 months, we were what this was a case where the which was completely wrongly issued.
So please call us. Yeah.
Watching up and I'm going to invite Akanksha up to present. Thank you, Akanksha.
Thanks so much, Mariam. Hi, everyone. I am Akanksha. I worked with iProbono India in the Bangalore operations from September 24 to September 2025. To give you a brief background, in Bangalore, we have over 20 panel lawyers handling 50 plus active cases. We partner with about 4 social justice organizations who are the main source of our caseload that we handle across the 8 fast track courts and the High Court of Calcutta. I'm currently pursuing my master's here at Cambridge. This is my college, my Edward. So welcome all, and thank you so much for being here. Today, I will present 2 case studies, and through these, I hope to give you a very immersive experience of our work in the trial and High Court of Karnataka. So let's go on this journey. For the first case study, I want to present a picture. I want you to imagine that you are 12 years old. You have survived sexual assault. You have been asked to come to court to give evidence against the person who hurt you. You arrive at the courthouse and you are told to wait in the corridor. Sitting across from you, separated by nothing more than a few feet of open space, is the accused. This is not a hypothetical situation. This has happened repeatedly in the courts that I have worked in. And this is the kind of gap between what the law promises and what children actually experience in court that defines my work at iProbono India. India enacted the POCSO Act in 2012, a fairly recent legislature. It was the first time that the law defined comprehensive range of sexual offences against children, created child-friendly procedures, mandated special courts for their trial, and placed the burden of proof on the accused rather than the victim. POCSO is a special protective law. Special courts are called POCSO courts, which are designated exclusively for these cases. And the law mandates that these cases should be completed within a year. It also offers victim support. The child is assigned a social worker. This is usually in Bangalore, we work with external social workers, about 6 of them. And in Delhi, there are in-house social workers who are part of the comprehensive care team. In reality, however, cases extend way beyond this 1 hour period, 1 year period, often taking 3 to 4 years for completion of the entirety of the case. Only one of the cases in the time that I was representing children completed within a year. The reasons for delays are often due to the absence of evidentiary record before the court, maybe due to police investigative lapses or other reasons, and the absence of witnesses who have come to testify, the accused is absconding, the reasons range. There are a wide range of reasons, but the delays are what affect the children in these processes. Infrastructure guidelines exist on paper, but they are frequently ignored, and the support systems that exist entirely depend on whether someone is able to activate them. POCSO courts in Bangalore are housed on a dedicated floor within the court complex. The law mandates specific safeguards for child witnesses. This includes a child-friendly waiting room where the child can sit separately from the accused before giving evidence. They also are supposed to have exclusive access to a child-friendly lift so that they don't travel through the main building where the rest of the litigants are, the route that the rest of the litigants are using. And there's also provision for a screen or video link during the testimony, so they never have to look directly at the accuser while testifying against them. As we frequently visited these courts with children for their evidence, we noticed that the waiting room was kept locked. Despite multiple requests to the administrative staff, this did not change. Children arriving at court were being made to sit in open corridors, sometimes within meters of the accused and their families, for hours, sometimes the entirety of the day, till their matter was called out. To address this issue, we first collated specific instances across cases, including the dates of their evidence, the cause number, the case list number of their case, and recounts of what the child had experienced that day in court. We mapped these instances against the very comprehensive and applicable vulnerable witness guidelines issued by the Karnataka High Court. Then we drafted a formal legal representation to be submitted to the administrative staff and court. We wrote a letter to the court registrar citing each specific provision of the guidelines which were being breached, attached the documented instances, and co-signed it with the social workers and panel advocates across all these cases. This was our mode of collective advocacy. It was not one lawyer complaining about an isolated instance or an individual occurrence, but instead a multi-stakeholder submission. Then we requested a meeting with the registrar directly. We presented the representation in person, explained the effect that this occurrence was having on the children who came to court, and ensured that the waiting room was open the following day and remained operational on a daily basis from then on. Beyond making the trial process as seamless as possible for the children, we filed compensation applications in every case. A child survivor is entitled to both interim and final compensation. Here, the interim compensation can be availed at any stage during the proceeding and ranges about £1,500. They are also entitled to final compensation to a final compensation order at the conclusion of their trial, which can reach up to £10,000 depending on the gravity of the offence. On top of this, we file applications for day-to-day allowances every time that they visit the court. This includes compensation for their travel, for their food on the day of being in court, to compensate for the daily wage that their family might have lost out on to come and fight for justice. These amounts are small, about £10, but are critical for families from severely disadvantaged backgrounds for whom attending court is an economic burden in itself. We filed these interim and final compensation applications in every case that we represented. We prepared witnesses, read over their statements to them, gave them an idea of how court procedures would work. We coordinated with social workers on psychosocial support and ensured that the procedural safeguards were operational and not just theoretically available. The result of this is not just individual outcomes for 50 plus children. It was an evidentiary tool documenting cases of systemic non-compliance that form the basis for institutional accountability. My second case study sits at the intersection of child protection and reproductive rights and illustrates what it means to work within a 3-day window to secure a child's access to abortion. Under the Medical Termination of Pregnancy Act in India, termination beyond 24 weeks requires court authorization. For child sexual abuse survivors who are pregnant and who often either know about their pregnancy at a very later stage or disclose the abuse only at an advanced stage, this creates an urgent procedural challenge. Time here is not just important, it is the difference between being able to avail this procedure as a medically possible reality or not. iProbono handled these cases as genuine emergencies. The moment we received a referral, we activated a fixed protocol. On the day 0, that is on the day that we get the referral, we first connect with the hospital to obtain medical records, confirming the gestational age and the survivor's fitness for the procedure. We also get in touch with the child and their family to collect their identity documents. Immediately after having the documents on record, we draft and file the petition either on the same court working day or as soon as the filing counter opens the next morning at 10 a.m. We mention the matter as soon as the bench sits at 10:30 and explain the need for an emergency hearing. The matter is usually taken up either after lunch or at the end of the court's working day, that's before 5 p.m. on the very same day. The court's first order is issued on the day of filing, and this order is to constitute a medical board to assess whether such termination is medically possible or not. On day 2, the hospital's medical committee submits its recommendations in a sealed envelope as a report to the court. In every case that we have handled, the recommendations usually support the termination. On that very same day, in the evening, the court passes its final order granting permission. So as you can see, the entire process from first contact with the child to the court order being passed is endeavored to be completed within a maximum of 3 working days, quite unlike other procedures in the health. What made this possible is preparation. We maintain template petitions, have relationships with hospital teams, and have a checklist of every document required to make sure there are no delays in the filing process. The MTP Act also provides that medical charges and compensation to the survivor are covered by the state. We ensure that these applications are filed along with the petition. The compensation awarded in these cases are about £3,000, along with an order that the state would bear the medical and travel expenses of each child. These were my 2 case studies. Thank you so much. Looking forward to your questions.
Thanks so much, Akanksha. And I'm just immediately going to call Priya up to the podium to share 2 very different case studies from a different jurisdiction in India.
Thank you, Maria. Hello, everyone. I'm Priya Watwani. I'm currently pursuing Masters in Public Policy at LP. I'm a lawyer by training. I have over 9 years of legal practitioner experience, out of which almost 7 years was spent working with that. So Akanksha has already touched upon the day-to-day work involved in running a trial court case in India, how lawyers, the iProbono team, social workers all work collectively to support each child. I want to zoom out a bit and take you through some of the systemic statewide impact that we were able to make at iProbono. I'm going to cover two stories. One is actually a first public interest litigation that I was a part of when I first joined iProbono back in 2018. And the second one is the last one that I managed back in 2023. So the first case is about a child's right to participate in bail hearings in POCSO cases, which are, like you know already now, child sexual abuse cases. Through our partner NGOs in Delhi that we were working with, we were informed of these two mothers who were mothers of child survivors of abuse. They were not being informed of the bail hearing, the bail applications that the accused was filing. Either they were not being informed at all, or they were being informed a night before at times, which left them essentially, them and the child survivor, with no real opportunity to have a say in it or to even know what's being argued at. Because usually the public prosecutors are the ones who handle these cases. And they represent the state essentially, and they are overburdened, as all public prosecutors are in many of the jurisdictions that we work with. They often don't even get in touch with the family or have a conversation with the child to know where they stand. And while the POCSO Act has provisions requiring the police to inform a child's family about arrest, bail proceeding, and essentially everything that goes on in a trial matter, these provisions were simply not being implemented. The presence of the prosecutor and the arguments that they were making were being treated as enough. But it's not enough. The child's perspective, their fear, the gravity of what they went through, the trauma needs to be heard too. So we filed a public interest litigation on behalf of these two mothers in the Delhi High Court. We engaged our panel advocates, a senior advocate to argue the matter. And while this petition was pending, the court in another matter issued practice directions under the Criminal Procedure Code requiring the informant's presence at bail hearings in serious rape cases. These were rape cases where adults were being abused. So we said, great. We argued that the same protections, the same guidelines should also be extended to POCSO. When the child survivor deserved at least what an adult victim was being protected. And so the court agreed. Guidelines were drafted and implemented relatively quickly, which, as we know how these things go, was a big win in itself. But here's what happened next, and that's where it gets interesting for me at least. Every time the accused now filed for bail because of the relief that we got from the court, which could be sometimes 1 or 2 applications in a month, the children were being summoned back to court to give their statement on each application again. So something that we did that was supposed to give them a voice was now traumatizing them because they had to come back into the court environment, face the accused, give their statement. In our trial court matters, though, we started pushing back. We said that if the child's counsel is present, they don't have to come to court. The child's counsel have instruction and they can argue the matter. But because the judgment came from the High Court, the trial courts and the judges were insistent on the physical presence of a victim child. So while we were preparing and getting more data to take some action against it, we had an opportunity where a bail hearing was happening in one of the High Court matters that our panel advocates was arguing. And the judge there was receptive to hearing this issue as well. So he called us out and he essentially said, I have the judge's attention. The matter is going to be listed again after lunch. Can you give us submissions right now? And we were like, yes. We put our heads together within an hour and a half. We drafted additional guidelines, submitted to the court. This included the point that if the child has made a statement before on the first bail application, for example, that statement can stand for the consequent ones. And things like if child counsel has instructions, they can argue the matter, the child does not need to. And if the judge really wants to hear the child and see what they have to say, they can request for a video conferencing. And the child can appear online or virtually with all the child safety protocols. All of them, all these guidelines were accepted. So children now are empowered to challenge the bail without being re-exposed to the accused each time. And again, we took these learnings that we had in Delhi and the judgment that we had in Delhi to file a similar case in Karnataka where Akanksha was working. And we got equivalent guidelines there as well. And of course, the judgment was then cited in many other state high courts going forward. So that was the first case. The second case that I want to tell you about covers a very different area of law, but still under the umbrella of child rights. I'm going to tell you about two sets of siblings from different parts of Delhi, which is the national capital, as you would know, I'm assuming. There was one 9-year-old boy and his 6-year-old sister. They were being abused by the alcoholic father, and their mother had abandoned them years ago. The father was arrested in one of such instances and later on died. In another case, there was a 13-year-old brother, a 13-year-old son, and his 9-year-old brother. Both their parents died in a domestic brawl between them, and they were both killed. When we looked into the case, we in fact found that the mother had repeatedly made domestic violence complaints but had no relief. So in both the situations, the relatives of these children refused to take them. So all 4 of these children came into the system, under the child care institution system in Delhi, and were placed in 2 separate institutions, as we call them, shelter homes. And what united them beyond unimaginable circumstances they had just gone through, was the same battle, securing the right to what their parents left behind. So India's child protection system does a reasonably well enough job in providing immediate food, shelter, healthcare. But what happens to inherited properties of these different children? Who is protecting those? Who is protecting the assets? Relatives could very easily move and take over. Sometimes children don't even know if they have any assets the parents are behind. And once they're 18 and they leave institutional care, they are basically left with nothing, no support, no safety, no back. And there is some legal framework that exists, but it exists in parts. We have the Guardians and Wards Act, which was enacted in 1890, a colonial era law, which was last amended, I believe, in 2010. And this allows the court to appoint guardians for the minors, who are often children as well, and their property too. And then we have the Juvenile Justice Act of 2015, which covers the child welfare system in India comprehensively, assigning roles and responsibility to every agency. But there was nothing linking these two legislation. There was no protocol, no accountability chain, no standard procedure of what should happen to the assets and properties of these different children, who should take responsibility. So again, advocacy happened on multiple tracks. We had to do the legal research to identify who can be the guardian of the property of these minors, which we identified as the district magistrate of those particular locations where the children were residing. So we wrote to the DM, we wrote to the district magistrate, and we got no response. So essentially, we had to work with the facts on record, the narrative of the children and what they had gone through. And on the basis of that, we filed 2 separate petitions, not a PIL or a public interest litigation this time, 2 separate. Because, of course, we wanted action to be taken in a very speedy way. But what we did was, at the very first hearing, we framed this issue as a systemic gap, which had left us with no choice but to approach the system, because we essentially had nowhere to go. So the judge was receptive and empathetic, and he directed us to work with the amicus that was appointed by him, the Department of Women and Child Development, to frame guidelines. And we were allocated only 2 months to do this task. We put the guidelines together, assigning very clear responsibility to across 8 agencies working in Delhi, which mapped onto the existing responsibilities under different legislation. And in parallel, of course, there is concrete action taken for the 4 children that I just mentioned. The district magistrate secured their properties, and the trial courts had oversight of what happens to those properties when they turn 18. And in fact, very interestingly, we ensured that we include a provision in the guideline that there should be a comprehensive handover process. So, for example, once a child turns 18 and they are out of the institutional care and they're being handed over the property and assets, a lawyer, a social worker, from some of the department should explain to them what are these assets, how do they work, how do they navigate the system. So these guidelines that we proposed were accepted in full, and they are now legally enforceable across Delhi, which means that it protects the right of every orphan child under the state care in the capital city. Why I chose to tell you about those 2 particular cases, because they give me very unique but connected learnings. First, that a good judgment is only the way. You have to watch and see how it trickles into the system, if it's being misused, if there are any loopholes, if there's a gap that we ignored. And sometimes you have to go back and fix it, either through courtroom advocacy or policy advocacy. So access to justice has to be treated as a living, ongoing commitment, not one courtroom win. And second, so much of what matters happen outside the courtroom. Writing letter to the administrator, the government departments, brainstorming with experts, being the facilitator of interagency dialogues, which can be tough in India sometimes. All of it counts. And this work not only made me a better lawyer, but a more purposeful one. It has brought me to the career that I look forward to now in legal and social advocacy. So I'm grateful to have shared these stories with you and open to all questions.
I think we go straight into the moderator's review because
Okay. Hello? Yeah. All right, so thank you very much. And so I'm now going to have the delightful pleasure of asking some questions. And I have to say, listening to you both, the span of the work you've both covered, just in a few examples, is enormous. And I get the very distinct impression that the depth of the involvement of the lawyers and those around you has been crucial to bringing about the successes that you have told us about. So what I'm going to do is I've got some questions arising from each of the things that you have talked about, but I'm just going to start with you, Akanksha, and just because I wanted to ask about the sexual abuse offences Act that you told us about. Now, when we had a little chat about this earlier, you did bring to life the way that you and iProbono and those with you use what you called a robust law, I think when you were giving your talk as well, how you systematically use that law to identify gaps and to ensure implementation. I think was a very interesting insight to me, and I'm sure others would find that also very useful. Because would you mind just explaining that a little bit more?
Thanks, Aswini. So I don't know.
There's a little red button there.
Yeah, but I think I'm like loud enough.
People online as well.
Is it on? Yeah. Okay, great. So as I briefly said, we handle over 50 cases. So when you're handling such a broad number of cases, what our attempt to do, as I was mentioning to Aswini before, is that we try to document how all the protective laws are being used in each of these. So when I mentioned interim and final compensation, on our end, what we do is make sure that every case that we represented, an interim compensation application was placed on record. And a final compensation application, we had made enough written submissions during final arguments to make sure that all the grounds that we wanted to raise in each case were put on. So the way we did this was we really worked with our panel lawyers to create a series of triggers where different protective applications had to be filed. In every case, as soon as the case came to us, we would file an interim compensation application, keep it on record. During evidence, we would take the child with the panel lawyer, prep them on their evidence so they had a better understanding of how the case would work, how the proceedings would work in court. So our attempt was, if we do this enough in 50 cases, if we make this the practice, then slowly but surely it would trickle down, as Priya mentioned, into the system. It would become an automatic process. It's both frustrating and important work because it does need that one person or that one agent to constantly reinforce the protections within the law. But I think it is very important work, the documenting of these procedures that we do, just to make sure that at some point, hopefully, it will become an automatic procedure and all children who are before the court will be able to benefit from it.
So do you monitor the documentation that you file so that you keep a record of what happens to it? Is that how you identify implementation and gaps? And what have you done about Do you have a quick
Yeah.
example of how you've used that?
Yes, so we generally across all our jurisdictions we have a tracking document where we have the details of all our cases, what happened in the last hearing, whether evidence has started, whether the compensation applications have been filed, and the idea is I can give you an example of the diet money applications. It was a system that used to be followed in Delhi very frequently, and when I was speaking to members of the Delhi
Diet money.
diet money is the travel money and the food money that I was mentioning. Every time that a child comes to court, it's usually the entire day of the child and their family goes to come to court, and that could be on multiple instances. So what we started doing is that instead of sometimes the social workers out of their pocket would give them money to come to court and things like that. Very unorganized means of ensuring that the child was able to make it to court and was able to sustain coming to court. But what we started doing is there's a very old archaic provision in Act, a 1967 Act, which is Payment of Amounts to Witnesses Act. I'm butchering the name, it's a longer name, but we would file applications under that and make sure the orders got allowed, like argue them before the judge, and the judges usually pass the order. But then what we encountered was once the order was passed, the money was not being realized from the cash branch because the order has to go to the cash branch and the administrative department. We needed to follow up a bunch to get that money. So as a starting point, what we started doing is we started documenting all the cases in which we had filed these applications and we had received. The idea is that if we are able to prove enough systemic non-compliance, at some point we could probably approach the High Court through strategic litigation and make sure that this becomes a process that had to be automated from the court. Yeah.
Wow, that is painstaking work. It clearly is. Thank you. I'm just going to turn to Priya on the same act, because we heard your encounter with it in terms of the public interest litigation you filed in the High Court around bail applications and the participation of the child victim in that context. Do you want to tell us something more about how you use those Hill applications in the High Court in the same sphere, essentially, to bolster the rights of children, and what sort of process that is, and how you did talk about how quick it was, and I was quite interested in that as well.
Yeah, so I think in India, public interest litigation is a very robust way to get quicker relief from the court, or when you want to have some sort of policy guidelines or directions to be passed. It's a good avenue to approach. Sometimes it does take a very long time. It's not like every PIL gets completed and heard in a few months. At times we've had cases which have run for years and years, just because the nuance to it in terms of legislations involved and the stakeholders involved can take some amount of time. But like I said, it's a very robust avenue which we have used many a times. But there is sometimes a difference. Sometimes you have to pick and choose. Like in the second case, we chose not to file a PIL because firstly, we did not have enough data or evidence. And it would have taken us a lot of time to file right to information in their applications, that we can get information on anything essentially. But in that case would have been how many orphan children are there? What are the property rights? All of that. So all that data gathering would have taken us a very long time to frame it as a public interest litigation. So in that situation, the fastest way was to file two separate petitions, get them listed together, and make our case in court then. Bring the issue to light in ways that through our submissions, through our oral submissions, that this is a systemic gap. There are these 4 children, but there could be so many more. There's so many thousands of orphan children in Delhi. So sometimes you have to pick and choose. And in the first case, public interest litigation made sense because these 2 mothers of child survivors firstly were willing to come forward, and they became representatives of many such cases which we had documented. So through our partner organization, who were also working with children, they had a list of cases where bail applications and bail information about the bail hearings were not being informed to the families. And we had a set of cases with us as well. So we presented that as evidence as part of the public interest litigation. And because there was already a practice direction that came from the High Court in a different matter, we were able to get relief fast, but it's not always.
Yeah. So obviously we're always very interested in public interest litigation because we don't really have that. And also the idea that you can present this sort of information for such immediate change. Am I right? It does sound as if you need this multi-stakeholder approach. So you're using evidence not just that you gather from your clients, but also social work evidence, evidence of impact on the victims. Is that right? So that must take time, surely, to put that all together.
It does take time, and that's why I think partnerships with other NGOs, civil society organizations, within our team, the social workers we work with, all of that really counts and matters because they are the people who are working on the ground. Most of the times, lawyers are somewhat little away from these issues. We sit in our offices and we think about our arguments in the law, and we meet children when we have to prepare them for testimonies and so on. But social workers and the agencies, they are the first point of contact. They are the ones who know about the psychosocial state of the child or the family, what economic background they're coming from, what kind of abuse was taking place. There are so many incestual cases in India. So they are the best people to sort of point to us that we're facing this issue. Can we do something about it?
I'm going to come back to that because I want to ask you about that in the context of your second example. Before I do that, I just want to go back to you, Akanksha, about the second example that you gave. Now, again, I mean, that sounds like you talked about the need to act with speed. You get your cases together in 3 days, I think you said. But there's a wider context here, isn't there, to the children and the reason why you're having to do this in terms of why they find themselves in need of termination and that sort of thing. I'm just wondering to what extent, and you explained that very well, to what extent you have any wider involvement in those issues for those children beyond termination cases?
Yeah, so because a child who's a minor and is found to be pregnant automatically triggers the POCSO Act because it is statutory rape, irrespective of the case. And the POCSO Act clearly criminalizes any sexual activity of a child below. I mean, a child is defined as someone who's below 18 years of age. So the way these cases come to us is because usually either children don't know of their pregnancy or they're trying to hide the fact of their pregnancy till it reaches a very advanced stage. Many of the cases that we dealt with, it's usually that the child, either through their parents or by their own accord, are visiting the hospital because for other symptoms that have come out of pregnancy. Sometimes they don't even know. So it is when they reach the hospital premises and they're found to be pregnant, another provision in the POCSO Act called mandatory reporting gets triggered because there is a provision in the POCSO Act that any professional or any person who knows of sexual abuse against a child has the obligation and the criminal duty. They can be criminally liable if they do not report such a crime. So usually the cases come through us through a doctor who has found out at an advanced stage that this child is pregnant. That means the criminal justice system, the way it operates gets triggered. That is, the doctor has to file a first information report before the police, and the MPP Act itself needs this High Court order if the child is beyond certain weeks of in their pregnancy. So beyond the termination, as you asked, outside of the compensation, the medical evidence of this termination is also preserved. It helps with the child being able to prosecute their trial at a later stage because, as I said, the FIR means that a parallel POCSO proceeding gets instituted in the fast track court. So here, the High Court order usually has another provision, another statement which says that all medical and DNA evidence from the termination has to be preserved. And that essentially helps in the evidentiary record in the trial. So these are the two facets in which they have.
Right, so that really does, promote the proper prosecution and hopefully successful prosecution in those circumstances. And are those provisions being properly used now in your opinion?
Yes, at least this aspect of it has to, because
It's a mandatory.
Yeah,
It's a mandatory.
yeah, the doctors don't want to take the liability on themselves, so they do pass on this.
Very interesting. Okay, thank you very much. All right. So I think I don't know how much more time I have.
We were just going to send you a note. Maybe one more question.
One more question
Priya,
I
and then
have.
we'll send it up.
Priya, thank you so much. So I promised to come back to you on the sort of multidisciplinary aspect of the work that's involved in the court cases that you do. So really thinking again about your property case, which is a very unusual, very interesting case, and the fact that you said you weren't using public, you explain why you didn't use public interest litigation in that. But I had been interested in to know how you even knew of those cases, because they seem like hidden away. I mean, I know a lot of it is hidden away, but so I just wanted you to just help us to understand that.
Yeah, that's a very interesting question and a very interesting story as well. So this particular case of protecting property was completely new for us at iProbono. We had not delved into this sector of child rights. So the way it came to us is interesting because there are two sets of children, two sets of siblings, essentially, from very different parts of Delhi. But coincidentally, they were going through the same thing around the same time. So one of the set of the cases came through us through the Child Welfare Committee, which is one of the first agencies that the child is brought to once there is any sort of harm or abuse done to them. They're the first point of contact, and they are the ones who trigger the system into ensuring and figuring out what the child needs in terms of psychosocial support or legal support. So that committee itself is from that particular district is someone we're working with. Particularly our social workers in the team provide psychosocial support we're working with. So they were in touch on a regular basis on various other cases of POCSO particularly. And one of the chairpersons of this committee asked the social worker that, we have this one case where there are these two children, they are in the system, they are being placed in this childcare institute, but we're very worried about them because the father is an alcoholic and we know that he has property in his name. And we assume that he might pass away very soon. They don't have a mother. So what can we do to protect these children after they turn 18 and leave the system? So we were like, okay, let's figure this out. The social worker came to the legal team at iProbono and they're like, can we do something about this? And we're like, okay, let's figure this out. And then we engaged panel advocates who we thought were experts who had some familiarity with the Guardians Involved Act and the family court system. We asked them to sort of brainstorm with them. Simultaneously, a month or two later, we were approached by another shelter home for the other set of children who said that these two children, we definitely know that both the parents passed away. We definitely know the property, they have some property. It was actually in the mother's name in that case, who was repeatedly filing domestic violence cases and to no relief. So they told us that can we do something about it? And we were like, how is this possible that they have these four children in very different parts of Delhi coming to us and say similar issue? So we put our brains together and we started working on it. But like I said, because from our end, we had no locus to look into what these property and assets are. We had to go to an official. And so we drafted that letter to the DM and it then proceeded on from there. But came to us from very different sources, and we had to look into the law that we were dealing with because it was, like I said, a very new provision, new legislation for us.
Right, amazing. And I think you also said that you then do follow up to make sure they do in fact get what that was owed to them.
Yeah.
Like I can see that Mariam is anxious. We should now
Wonderful. I mean, if you want to ask
bring
a
this
question, but
no, that's fine. Let's I think we
involve
should
the floor a little bit
give
as
everybody
well.
else a
That's
chance
what they-
now as well.
Yeah.
So
The roving mic.
right. So shall we start in the room? Shall I do this?
Please, yeah.
Okay, so are there any questions in the room? There's questions, gentleman at the back there.
I'll run across. Any other questions?
My name is Aditya. I'm a student here at Cambridge as well. Thank you very much for a fantastic session. My question is about one state specifically in India, Meghalaya. West Garo Hills as a district is one of the highest number of POCSO cases, both pending as well as disposed. The reality, however, is that a lot of the tribal communities in the state, the Khasis, the Jaintiyas, the Garos, etc., it's very common for them and in line with their tribal custom for them to marry at the age of 16. And technically, the sixth schedule of our constitution preserves this right, broadly speaking, enables them to follow their traditional practices. However, once they visit the doctor, as you pointed out, Akanksha, mandatory reporting kicks in and the authorities are forced to prosecute. The High Court of Meghalaya has expressed concern over this several times, but there seems to be no easy answer. So, as practitioners in this area, what's your view? Should we just apply a bright line rule and enforce the law uniformly across the country, or should we, try and carve out the application of the law in some areas like this?
So in another context, this is an issue we face. I'm glad you asked this question because it's so complicated that it wouldn't come out in a straightforward answer, because we do face a lot of cases of consensual romantic relationships where children at the age of 16 want to be together and maybe even want to continue with the pregnancy and things like that. But so there could be a case where there is a pregnant minor, 16 years of age, whose boyfriend or husband at times is in prison because of the POCSO Act being applicable in this case. What does happen is there are these individual high court orders, decisions, which look at it as a fact-specific occurrence and have passed. Even the Supreme Court of India has passed judgments which say that you have to look at this, the facts of the case, and accordingly decide whether the stringent law of POCSO should be applied, because POCSO Act has very high imprisonment times. If they're found guilty, it's over 20 years of imprisonment. So the high courts in individual cases have applied their mind to the facts and decided differently. And there are multiple child rights activists who keep advocating for these class of cases, which we call Romeo-Juliet cases, and try to carve out an exception, maybe lower the age of consent. But again, because there are so many cases, and the implications of reducing the age of consent might create other challenges which we can't predict. So unfortunately, there are a lot of boys who fall within the juvenile justice system and are for being in a romantic consensual relationship. But the only solution so far has been through individual cases in the appellate courts.
Priya, do you want to add anything? Yeah.
Sure. Any other questions?
I think this. Yeah.
Yeah.
Red button. Give a push. Okay.
We have two questions.
Right.
Just for the three of you, so I need to first one is because the range of the spectrum of issues with regards to sexual assault is so wide, because I see a lot of the newer cases or the cases that we see right now are also committed by juveniles. And as public policy students, we see this as an intersection of a policy issue as well as a legal issue. So where do you think the two intersect? Or are they mutually exclusive?
So I'm going to ask Priya that because she's the policy person.
And I also have another one.
So let's do this one and then I'll do them one at a time. Yeah.
So, yes, they currently, as Akanksha mentioned, as the law is pretty strict about it. They are treated as juveniles. If the perpetrator is under 18, they are treated as juveniles. But the law for them is a little bit different. We have special protections if the accuser is a child as well, which comes under the Juvenile Justice Act. And they are handled by not your normal courts, not your trial courts. They are handled by juvenile justice boards. which are again district-wise spread out in every state. So yes, I mean there is complication there when you think about the Romeo and Juliet consensual relationships, but in terms of it being a legal issue or like a policy issue, I think it's a bit of both, and that's why there's a lot of activism right now going on, thinking about the age of consent, or thinking about the situation that boys are put through when there are cases against them. Situations like, so there is a different, so they're not put in jails, but essentially they're put in different homes, let me call them, and they're different for the age group that they're in. But at times we've noticed that boys who have committed very serious crimes are living with boys who are sort of maybe committed theft, for example. Living in that environment, it's a very harsh influence on them, and a lot of them come out of that system even more harmed than they went in with. So there is that gap that still exists, and I think iProbono does a lot of work with juveniles now, not just children who are survivors or victims of abuse, but also to ensure that juveniles are getting rightfully represented and their rights that is mandated under Juvenile Justice Act, I mean in POCSO, they are also being implemented, and we have filed strategic litigation on that as well. So there is a lack of attention, I would say, when it comes to perpetrators who are children, but everyone has sympathies for the victims who are children. So it's a lens that we have to also change as a country and look at children as children. You would add anything? No. Your second question.
Another thing is personal, I think, because a lot of this work brings in a lot of hope, the things that you, Akanksha and Priya, you talk about. But it can also be, doing this every day can also be super triggering. So what keeps you going, and what do you hope to do after your respective?
That is an excellent question. That's an excellent question in terms of, how you protect yourselves. So I'm going to ask you to have a go at that one first.
I think we discuss it with each other. I remember we used to have capacity building. iProbono gives us some money for our own therapy. So you will need some therapy, and you talk to each other, and you also, like, for instance, Lottie and I did a writing workshop with iProbono. So you find different avenues to kind of get out the frustration with the system. Because I remember very early on when I joined the development sector to speak, a person way more senior than me said, "Don't think anything is going to happen in a year. It's going to take 30 years for anything to change." And as I spent more time, people would come in and say, "I don't think this is going to happen in my lifetime." So these are the kind of timelines with which people are working, which can get frustrated. I think the fact that we're trying to study more and academically understand these issues more is also a response to the fact that you don't know what to do with all these tensions and all these problems that don't have a solution. And yeah, you talk to each other, you try and write about it, you do therapy. What I have done, I'm sure Priya would like.
And also, I must add another layer, because you're dealing with pretty horrible problems.
Very, very tough question. Honestly, there is no easy answer to it. I think everyone has their own ways to, or find their own tools to cope. But I think initially when I joined and I started working on these cases, it really did impact me on a very personal level. Not to the effect that it was affecting my functionality, but I think just seeing this day to day especially when you meet the child. It's different to read it on a case file and just read about their statements and what happened. But when you actually meet them in person and have to guide them on what they should be, how they should navigate this process and what's going to actually happen to them in court in terms of repeatedly being asked questions about a very gruesome situation. It does impact you. Of course, the tools that iProbono provided were helpful as well in terms of therapy, in terms of team check-ins. I think it was really, I've been very grateful that my managers and the team around me were always a very open door policy, so to say. We could text each other and talk about anything. But I would say, as someone who was pretty young when they got into it, I was 25, 26. It took time for me to adjust and not take it so personally. At the end of the day, what we can do is just try our best. Put in 100% is, and we have to realize it's not just us. We are working together as a team, as a judge. There are other lawyers, there are social workers. We're all in it together. But to take that responsibility only on your shoulders sometimes can affect you. So over time, I realized that I need to be able to say that this is not just on me. And maybe in time, just figure out what works, what doesn't. But you do feel that pressure that if you don't take that action, if you don't make that call, or if you say something wrong while arguing in court, it could have a consequence to the child, not you, but the child. So that there is a level of very, overbearing responsibilities. But I think with training, with the support, and over time, when you see this day in, day out, it helps.
Shall I add my tuppence into that?
Yes, please.
Yes, please.
So the over 30 years experience of culture. So when I first started doing child abuse cases, it was at the beginning of my career, and that's in the civil sphere. And there was no understanding of the need to protect lawyers from not just what you're reading and the impact of that on you, but also the responsibilities that you spoke of. Over time, and it has taken all of that time, I think now the fact that we have those protocols and guidance and procedures around all of that, it does alert you to the fact that there is something else going on that needs attention, and not just necessarily for the victim, but also for those around, that there is something to safeguard. So I think those are sort of protections, but also I think our regulators now are much better aware, and my chambers, for example, Chambers is very aware of the need in providing therapy and outlets for people. Our criminal practitioners, for example, deal with, as you can imagine, some pretty horrendous cases. So that, and we like to think that we're robust, but actually sometimes someone needs to just nudge you in the right direction and say, it's time, don't you think, just to take a break or something like that. So that has now, it's evolving, but it's a lot better than certainly 35 years ago.
Thanks so much for sharing that. I think I saw one more hand up somewhere. Any other questions? Thank you.
Thank you so much. Just a question to sort of understand a little bit more about the teams that you work within. I've done a little bit of strategic work, and I just would be really grateful to understand sort of what your teams look like, the roles, how you sort of work together with, sounds like, the social workers with these panels. If you could just explain a little bit more, that would be helpful.
Most good first.
Priya,
You go.
people.
So yes, there is the in-house team of iProbono, which of course has grown over the years. When I joined, we were 4 people. By the time I left, we were over 20. And this is just in Delhi. So we expanded to other jurisdictions. Bangalore, we had Akanksha and other members before her. We've expanded to Mumbai, we've expanded to Rajasthan and UP, Uttar Pradesh. So a lot of states with their own teams. And while we were expanding the in-house team, we were also expanding the panel of advocates that we had. So how it works was that we used to essentially recruit panel advocates. These were lawyers who were experienced at both trial or high court level, who used to apply, be able to work with us on a pro bono basis. So this is something they used to do out of their own conscious, I feel. They felt the need to give back. So they used to carve out time from their practices to manage these cases as well. And the support they got from us was, I think, the useful portion, useful part of enabling them to do this, because we had a team of lawyers who used to support them with everything essentially, all the client management, research, sometimes even arguing in court if they are not able to appear on the day, drafting applications, meeting the children, organizing those meetings, and so on and so forth. So that support we were able to provide them. And then we also added social workers into the team over the years. I believe still it's only in Delhi that we have social workers.
I'm just going to add that model's adapted significantly, so that we're now running cases in-house with our own in-house lawyers. And we work with pro bono panels, but also with reduced fee panels of lawyers. So in different states, to make the work more realistic. It's not realistic for every lawyer to work for free, but to provide a reduced fee, particularly at the trial court. And actually the idea for getting social workers in came from one of our junior lawyers who worked within the iProbono in-house team in Delhi. It was a brilliant idea. We work very closely, as you mentioned, with child welfare committees. And this sort of model is replicated across our different countries in South Asia as well. And it tends to work because it's sharing the work across the board. And I think our stakeholders as well, so our NGO partners, our other government stakeholders are also really important to making this work into a reality. I think people almost think of it as a solicitor barrister divide that we have in the UK.
Yeah, so initially we used to work with partner organizations, and they used to refer cases to us. And then, like Maria mentioned, we had our own social workers in our team who used to directly engage with these government agencies, especially the child welfare committees. So we started getting referred cases for psychosocial support, and out of which we used to examine which case needs can lead to a legal support matter as well. And that's where lawyers and panel advocates used to come in. And besides that, because we were doing a lot of advocacy and capacity building work, also is areas we expanded to. So when we were going to trainings or legal awareness sessions, we were expanding our reach to other states where we in particular don't have a panel of advocates, but we could potentially do, and that's how we expanded to Rajasthan and UP. We started by doing events and workshops with lawyers, with judges, with law students, to tell them about our work, build our partnerships, and we slowly grow that.
And I'm way Priya is using the past tense.
Yeah.
It's still very much part of the iProbono team. I see one more question here. Is it okay if I take that, Aswini?
Do it. I'm just worried about people online, whether they need their questions are answered.
Any questions online, Lottie?
Oh,
I know I work on forced marriage in the UK. So I wanted to ask all of you, in fact, about the criminal justice system and the police. So, and I am from South Asia and have some experience of all three countries that we work in South Asia. So, Akanksha, you mentioned FIRs. So the fiddly bit and the evidential bit, the important bit, not the FIR. So do people actually, which is the first information report, do people actually work with the police? How do you go about that? Because that raises a lot of problems even now, because the police don't often understand the law and they don't ask the right questions. And especially when it comes to children and minors, it's and families who are not used to giving evidence or even reporting a crime. So if you can say a little bit about that.
Yeah.
Yes. Yeah. In that at least in Bangalore, we don't actually start working on the case from the FIR, from the first information report stage, because once the FIR is lodged, is when our partner organizations usually get to know about the case and refer it to us. What we do is sometimes, because of, as you mentioned, the lapses in investigation, sometimes the FIR does not capture the extent of what offense took place. So then if there are multiple statements that the child has to make, first before the magistrate, then before the court again. So what we try to do is make sure that the statement is corroborated enough so there are no gaps in the testimony of the child through the process of the court. So that may mean sometimes not saying everything that was not said before, like just maintaining a consistent story. So there is some amount of strategy that is involved just to make sure that the case stays consistent. But there have been a lot of issues because of all the evidence not being placed on record, or it being, or the DNA evidence being tampered with. And these are issues that, as Priya briefly mentioned, we do try to handle through capacity building trainings, which is, maybe you want to elaborate? Yeah.
So like Akanksha mentioned, it's not a direct engagement when it comes to the case work, because our points of contact is this child welfare committee, because once the FIR is lodged, the child has to be produced before the child welfare committee. They don't have to deal with the police, go to the police station, you have to come before these committees. Well, the police is involved in these processes, these procedures, but our point of contact is the child welfare committee. Having said that, we have been doing a lot of capacity building work with the police. So in terms of training them on the POCSO Act, the guidelines, the rules, how to deal with vulnerable witnesses, all of that has been going on for years. We've in fact also started to do trainings on the Juvenile Justice Act. So if you're dealing with children who are the perpetrators essentially of juveniles, there is a certain sort of sensitivity and training that you have to ensure that you deal with them in the ambit of the law. So all that capacity building work has been going on for a while and it continues to happen in different states.
What's the time, Doughty? Do we have time for one question? Just mindful that we want to get people coffees and drinks.
Comes about 6.
So I'm gonna ask Aswini to wrap up, I think. And
Okay.
would that be okay? And then we can all join forces and have a cup of tea together. Thank you.
Okay. I'm more than happy to do that. Well, I mean, I guess what I would say is just to bring together the things that we've heard from both Priya and Akanksha, and to say thank you to them both for sharing their incredible experiences and their incredible work with us. A very impressive range of work, which I've already drawn attention to, and the demonstration of how painstaking attention to detail and to impact and to implementation pays dividends and produces results which are meaningful, I think is what we've seen. And the teams that you work in and the things that you've said about the sort of multidisciplinary approach that's taken, I think we all understand that otherwise these things would fall through gaps. It takes dedication in order to bring them to work. And so I just think we should say thank you very much.
We'd like to welcome you to a fantastic moderation and to those who are joined online as well. Please join us for a cup of tea or a cold drink.
Well done. Okay. Nice.
Sounds really interesting.
Yeah, brilliant questions. Really, really good. Really, no, it was inspiring. Yeah, it was really inspiring. I know, I was brilliant.